When you contact Lawrence and Associates with a case, one of the first things we'll ask you is what social media accounts you have and whether they're set to private. It is very, very important that you do this. If you file a lawsuit, your social media accounts can and will be browsed through by the insurance company or the attorney on the other side. And if they find enough in your social media accounts that they think they want to look through the entire account for even posts that are marked private, they can ask a court and get from a court an order that you turn over your username and password. Think about everything you've ever posted on social media and how much you would not like all of it to be read in a courtroom. So what do you do about that? First, always set your account to private. Second, if you post anything at all about the injury, leave out what you intend to do about it in terms of the civil court process. And three, make sure that any posts you're making while you're recovering from your injury are actually from the time of your recovery. Because if you're posting things that happened a year ago, they're going to show up with a date stamp that says that you were hurt while you were doing that thing. Here's a couple of examples of how that can hurt. So first, I had a client who was injured in a car wreck, off work. She was hurt. She had surgery, a lot of things going on. While she was convalescing from her surgery, laid up in bed, she decides to go through her old photos on her phone and she starts posting to social media. One of the things she posted was being on a cruise and going rock climbing with a date stamp that said it happened during her recovery. So the insurance company is refusing to pay her. They're challenging, thinking she's not as hurt as she is. We don't know why yet because we didn't know that post had happened. And they take her deposition. She has to sit down in a room under oath with a bunch of attorneys and a court reporter typing down her every word. And the first thing the other attorney slid across to her was, can you explain why you were going rock climbing when you've told us that you can't work and you can't get out of bed? Now, she had a reasonable explanation, but it took her a lot more time and effort and anxiety to get to the point where she could explain herself. And if that account had been set to private, she never would have had to explain anything at all. Another good example of social media gone wrong is a client that was injured in a golf cart accident. The cart flipped over on him. He had broken bones, non-surgical luckily, but he had filed on the golf course because they did not maintain the cart path, and that lack of maintenance caused the golf cart to flip on him. When the golf course refused to pay anything before litigation, one of the things their adjuster sent was something he had posted 2 years before his injury. And in that post, he was admittedly stupidly standing on the roof of a golf cart with the sun behind him, his arms raised in a V, holding the golf club up in one hand, and the post said something along the lines of, "What a glorious day." Now, was it stupid for him to climb on the roof of the cart? Yes. But did that cause him to be hurt? No, that was 2 years beforehand. And the fact that he did something stupid 2 years ago doesn't mean he was doing something stupid at the time he was hurt. Nevertheless, again, he had to file his claim in court and have an attorney look at it and overrule that adjuster. And it all could have been avoided if his account was set to private. So don't make that mistake. If you think you might even need to maybe file an insurance claim, immediately put all your social security accounts, your social media accounts on private.